neighborhood, compared to the police station, which is far many more police officers, we can see that the less police-dominated atmosphere was in fact in that police car right in front of the defendant's own home.
Well, it was pretty clear, though, that the officers had focused their attention on the defendant. It was pretty clear that they were investigating a crime, and he had been there for, I thought counsel said a half an hour. I'm not sure what the facts say on that subject, but all of those things considered would have led a reasonable person to believe that he wasn't going anywhere, right?
Well, Your Honor, what we have here is not just exactly the length of the interrogation. It was only 30 seconds long, as counsel correctly stated. And 30 minutes, Your Honor, is not a lengthy amount of time. It's relatively short. And this is all it took for the police to conduct their investigation with the defendant in this case.
The 30 minutes transpired from the initial contact until the defendant made the statement in the back of the locked patrol car.
That's correct, Your Honor.
Okay, and from the very beginning, it was clear that the officers viewed him as a suspect.
Not necessarily, Your Honor. Now, when the defendant walked up to the police in this case, counsel tried to, or was explaining that this case is similar to Herndon. However, Your Honor, what we see in this case is in Herndon, when the police officers rushed to the defendant and began accusing him, where are the drugs, where are the drugs? We can see in our case that when the defendant walked up to the police officers and the police asked, do you want to talk to us about the events of this evening? That wasn't beginning with any sort of accusation, and even later on when the police said, we think you might have been involved in the accident involving the cyclist, there was no sort of direct accusation of any sort of guilt on the part of the defendant.
All right, proceed.
Now, Your Honor, in Oregon versus Mathias, the United States Supreme Court made it clear that police officers are not required to administer Miranda warnings to everyone whom they question. Miranda warnings are only required when there has been such a restriction to a person's freedom as to render them essentially in custody. Now, Your Honor, when determining whether a person is in custody for the purposes of Miranda, the court must take into account all of the circumstances surrounding the interrogation. And as the court in Stansbury versus California stated, this type of test is entirely objective. Whether a person is in custody depends on the objective circumstances surrounding the interrogation and not on the subjective views of each party.
Let me ask, I think counsel focused on the fact that, it would have perhaps been clear to the defendant that the officer had her sit in the back seat because the defendant said that she was cold and he was just trying to get her in the warm patrol car. But he said that Mr. Edwards also argued that when he shut the door later on, it wasn't out of a concern for the defendant's, or out of a concern for the defendant's comfort. Would you comment on that argument?
Well, Your Honor, this circumstance does not relate to the police officer having the defendant sit in the back seat of the car. The police officer in this case, Officer Wright, just simply stated that, you can sit in the back of the car if you'd like. And the defendant herself said, the police officer in this case suggested that the defendant sit in the back seat. At which case, Your Honor, this was an option. The defendant could have said, no, I'd rather not, I'd rather stand outside. However, Your Honor, in this case, the defendant went ahead and sat on the edge of the seat.
Well, but when the door was closed, it was clear that she couldn't leave. Wouldn't you agree?
Well, Your Honor, as Mr. Edwards pointed out, there was 3 different circumstances during the course of this investigation.
Right, but the statement was made after the back door was closed, so we've got to be concerned about that, right?
Yes, Your Honor. And the first of these circumstances was when the defendant herself was standing outside of the police car. The second of these, when the defendant was sitting on the edge of the seat with her feet still firmly planted on the ground outside. And, Your Honor, after this, the police officer in this case could not just shut the defendant in to contain the defendant. The defendant's legs were still outside of the car. So the defendant had to voluntarily get into the back of the police car, and that's what she did. She completely obliged with the police officer's suggestion in this case.
Thank you. Proceed.
Now, Your Honor, it is clear in our case that there was no formal arrest prior to any questioning. So we have to look at the facts of this case. In Berkemer, the court held that when there is no formal arrest prior to any questioning, the only relevant inquiry is how a reasonable person in the defendant's position would have understood what was happening and carried out with what they were doing. The Supreme Court in that case stated that to be in custody, a person's freedom must be significantly restrained. Furthermore, Your Honor, Yarborough versus Alvarado discussed factors such as whether the defendant came to the police station on his own or voluntarily. Yarborough also discussed factors such as the defendant's age and criminal history. Your Honor, Yarborough stated that these factors were subjective factors.
2 minutes.
Factors that would turn an otherwise that would turn an otherwise objective circumstance into a subjective one, which would make it much more difficult for police officers to understand and to carry out. Furthermore, Your Honor, the circumstances surrounding this case does not create a situation where a reasonable person would feel that their freedom had been restricted. The defendant in this case was not arrested. The contact with the officers was not lengthy. The defendant was outside of her own house and not at the police station. Your Honor, for much of this conversation, Officer Wright was calm and friendly. And when Officer Wright noticed that the defendant was shivering in the cold, and the defendant herself even said, "Don't you think it's a little cold out here?" Officer Wright did what any good officer would do. She allowed the defendant to sit in the back of the warm police car. And that's what the defendant did, Your Honor. She did so voluntarily. But, Your Honor, for much of this conversation, the defendant wasn't even all the way into the inside of the car. She simply sat on the edge of the seat with her feet still firmly planted on the ground outside. The defendant voluntarily entered the back of the car to get out of the cold. Now, Your Honor, we can see that this court has to look at the totality of the circumstances when determining whether this was a custodial interrogation. The fact that the Officer Wright told the defendant she thought she might have been involved in the accident involving the cyclist is not dispositive. This court has to look at the total picture.
30 seconds.
Now, Your Honor, the totality of the circumstances in this case would not create a situation where a reasonable person would believe that their freedom had been restricted. There was no violation of the defendant's rights against self-incrimination. Therefore, Your Honor, the people respectfully request that the court deny the defense motion to suppress. Thank you.
Thank you, Mr. Hamby. Mr. Edwards, does the defense have a rebuttal argument?
Yes, Your Honor. No, Your Honor, the prosecution talked a lot about the facts, the surrounding facts and circumstances in this case, the totality of the circumstances. If we look at the totality of the circumstances in this case, Your Honor, it's clear that Adrian Vega was in custody. Now, Your Honor, Mr. Hamby specifically said that Officer Wright in this case did what any good officer would do. And Officer Wright did in fact do what any good officer would do. She engaged in a ruse with Adrian Vega. This teenager comes up to her house. Her parents are out of town for the weekend. She approaches her house and there are 2 police officers standing in her front yard. The lights on the police cars are going. The radios that the police officers are carrying are making noises. She's exhausted from her swim meet earlier that day. And the police officers see her coming toward her house and immediately identify her as a suspect. Then the officers engage in conversation with Adrian Vega. In fact, it's a coordinated effort on the officer's part. Officer Wright even gestures to Officer Jackson, indicating he should stand in the yard during questioning. So Officer Wright and Adrian Vega engage in conversation, asking Adrian question after question, before moving Adrian Vega into the back of a caged police unit and shutting the door on her. At this point, Officer Jackson is still standing a mere 15 feet away in the yard, staring at Adrian Vega throughout the course of the interrogation. Adrian Vega, during the interrogation, is simply giving quick shrugs of her shoulders and not even really answering the officer's questions with words. Adrian Vega then makes her potentially incriminating response and is then immediately arrested by the police officers. This is clearly a ruse on the police officer's part, Your Honor, and therefore the defense once again asks that Adrian Vega's statements be suppressed from trial. Thank you.
Thank you, Mr. Edwards. Mr. Hamby, the people have a rebuttal argument?
Yes, Your Honor. Now, Your Honor, Mr. Edwards stated that there were fully uniformed and equipped police officers, and Officer Wright was staring and standing outside of the police car in a menacing way to the defendant. But, Your Honor, if we look at case law and we understand that the fact that the officer was staring and the fact that the officer was imposing to the defendant, as we can see in Yarborough versus Alvarado, these are types of subjective factors, factors that we cannot consider in this court. The fact that the officer was standing outside with a menacing eye does not have any impact upon this case. What we have to evaluate is how a reasonable person in the defendant's position would have understood the circumstance. And the fact, Your Honor, that the officer was standing outside and looked scary and imposing doesn't change the fact that this was a non-custodial setting. A custodial setting is when there is such a restriction of a person's freedom as to render them essentially in custody. And Your Honor, when we look at this caged police car, as Mr. Edwards states it, Your Honor, we have to look to Green versus the Superior Court. Now, the fact that the defendant in Green was inside of a locked police room, inside of a police headquarters, surrounded by police officers, didn't mean that he was in a custodial circumstance. Your Honor, the doors to that room were locked, and just as in this case, the defendant was sitting inside a locked police car. But Your Honor, in Green, the court stated that just because these doors were locked didn't mean that the defendant was in custody, based on the fact that the defendant was not cognizant of the fact that these doors were locked. Therefore, Your Honor, the people respectfully request that the court deny the defense motion to suppress. Thank you, Your Honor.
Thank you, Mr. Hanky. Well, both sides have made excellent arguments, but the court is convinced that the defendant was not subjected to a custodial interrogation. It's pretty clear that the officers at no time told the defendant that she was under arrest. The handcuffs were never placed on the defendant. And although the defendant was placed in the back seat of the patrol car, there's no indication that the defendant objected to that or even knew that she was locked inside, that it was done because the weather was cold and the heater, I believe, was on in the car. So for all these reasons, the motion to suppress or exclude the defendant's statement is denied. Now we'll proceed with the trial. If you could perhaps change places. Are the people prepared to give an opening statement?
Yes, Your Honor. At this time, may I ask permission to approach the exhibit during my opening statement?
Permission granted.
Your Honor, this case is about accountability. We are asking that you hold the defendant accountable for her actions on April 19th. The evidence presented tonight will prove that the defendant drove her father's Bueller down Skyline Drive when she struck Cameron Douglas and kept right on going. Now, the defendant is a star swimmer on the Hidden Valley High Swim team, and she participated in the qualifying meet on April 19th. She had a great meet, and even caught the attention from the scout from the University of Los Angeles, her dream school. This scout gave her a business card and a cardinal and gold baseball cap. Tony DeLuca was with the defendant after the meet. The defendant was distracted, texting while driving, and when Tony DeLuca felt a large bump at the front of the car, he asked the defendant what happened, to which she immediately replied, "We didn't hit anything." But Your Honor, the evidence in this case will prove that she did hit something. She hit Cameron Douglas. Cameron Douglas will testify that he was riding his bike down Grand Avenue when he looked up and saw the face of the driver. And Your Honor, when Cameron Douglas looked up, he saw the defendant in the driver's seat. Now, Cameron's statement is corroborated by Quinn Liu. Ms. Liu will testify that she saw the driver wearing a white t-shirt and a cardinal and gold baseball cap. When Officer Wright investigated the Vega residence, she saw the defendant wearing a white t-shirt and a cardinal and gold baseball cap. Officer Wright continued her investigation and found the business card underneath the driver's side seat. The defendant denied driving the vehicle. However, when questioned, she stated, "It was a bicyclist. I'm so sorry. I could never forgive myself." Your Honor, the evidence presented during this trial will prove, beyond a reasonable doubt, that the defendant and no one else was the driver. We will stand before you again and ask that you hold the defendant accountable for her actions on April 19th by finding her guilty of felony hit and run. Thank you.